My name is Diana Shepard. I'm the editorial director of Divorce Magazine and a facilitator for the Divorce School. Today, my guest is family law attorney Ginger L. Dugan, who'll be answering some of the most frequently asked questions about division of property and debts, as well as bankruptcy and divorce in Florida. Ginger practices in all areas of family law, including divorce, spousal and child support, asset and debt division, and retirement and pension division. She also practices wills and trusts, probate, and bankruptcy law. Welcome, Ginger.
Thank you.
Let's start by talking about different types of property in divorce. First off, Florida is an equitable distribution state. What does that mean?
Equitable distribution means fair. It usually, in most courts, means 50-50 division, but it doesn't always have to be 50-50. So in cases where one spouse makes significantly less than the other spouse, then it may not necessarily be fair to give the spouse with more income, a 50% of the assets. It may be more fair to give the spouse with less income more of the assets. So generally speaking, we say it means 50-50 division, but equitable means fair, so that could mean a different division of the assets.
How does Florida define marital property and separate property? What's the difference, and why is it important to know which is which?
It's very important to know which property is marital and which is non-marital, because it really matters as to what the division of property is going to be. Marital property is, generally speaking, the property that is acquired during the marriage of the parties. So we look at the time from the date of the marriage until the date the petition for dissolution of marriage is filed. During that time, assets can be acquired by your income, and it doesn't matter whose income was used to make that asset. That will be a marital asset unless there's some kind of premarital agreement or prenuptial agreement that changed that. But under the laws of Florida, anything acquired during the marriage will be considered marital unless it's acquired from a source such as an inheritance or if it's acquired from a premarital source. So if you had a house that you owned prior to the marriage and that house was rented out and those renters paid the mortgage and you never, put your income towards that house, then that house would be marital. That house would be premarital, would not be marital, and that house would not be part of your equitable division of property in Florida.
How are joint debts divided in a Florida divorce?
Generally, we try to have people pay the debts according to their ability to pay. So if one person has a whole lot more income than the other person, that person would probably take on a little bit more debt than the other person. We try to divide it so that it's fairly equal, but once again, we're talking about equitable instead of equal, so that it may be that the person that makes more money pays more and the person that makes less money pays less. And really, you're going to try to work this out on your own. The attorney will work with you to try to come to the best resolution. You don't want a judge doing it, because if a judge does it, they're just going to say, okay, this much to this person, this much to that person. It may not be something that you're even able to pay. So you want to try to work it out as best you can. And it may be that the parties are, required to both pay 50%, but once again, this is equitable, not equal, so it could be skewed different ways.
Is it possible for an asset to change character from separate to marital or marital to separate? And if so, how?
Yes, we see this all the time where somebody has owned a house prior to the marriage and then they put the name of their spouse onto the property. That is probably the number one way I see assets change from premarital or separate property into marital property. The other way it can happen is if you get an inheritance, let's say your father passed away and you get a $10,000 inheritance. If you take that money and you put it into a joint checking account that has both parties' name on it, and both parties are kind of using that money out of that account, then that is another way to make that marital. It's a little harder to go from marital to non-marital. The only way we would really see that happen is if you had some kind of post-nuptial agreement where you agreed that something that was marital, such as your marital residence, would then become the separate property of the other party. But generally speaking, we don't see that happen unless there's some sort of post-nuptial agreement or agreement after the marriage has already happened.
If someone is concerned that their spouse might try and sell marital property before the divorce is final, maybe to a family member for a fraction of its true value, or maybe to try and pocket some or all of the proceeds, how can they prevent this from happening?
If we're talking about real property, like land or a house or something like that, There is a document that you can file called a lis pendens that actually lets everyone know that it's filed in the public records, so lets everyone know that you have a divorce pending and that piece of property is at issue in the case. And then the parties cannot sell the property during the pendency of the matter. If we're talking about things like cars or furniture, there's usually in every county the court will issue what's called a standing order that says you cannot sell things. And if someone does, then you can hold them in contempt. And so the way I see that usually happen is if someone sells a car that was worth, let's say, $25,000, and there's $100,000 in assets total, that would be considered part of what they received in the equitable distribution of property. And the court does not like it, so I would never suggest doing that. Always try to go by the rules.
You mentioned prenuptial and postnuptial agreements. I'm wondering if those type of agreements override normal property division rules?
Yes, they do. It really depends on how the document is written. But if you have a premarital agreement that describes how property will be divided, that agreement will be followed as long as it was, entered appropriately and it's a valid agreement. So it's really important if you do have one of those agreements, let your attorney know as soon as possible so that they can give you good advice, because otherwise they're going to advise you on the law. And those prenuptial and postnuptial agreements will change what the law does with respect to equitable division of property.
Can you get a divorce without having to divide marital assets and debts in Florida?
If you don't really have any assets and debts, you can, and the other party doesn't ever respond to the divorce, you can get what's called a default divorce that basically says everybody keeps what they already have. But otherwise, the court isn't going to grant the divorce without handling everything within the marriage. So if you have assets and you have debts, the court will want that to all be handled within the divorce. Sometimes we see motions for bifurcation, which means, asking the court to give you a divorce before dividing the property. So in other words, make it two different cases. Usually those are not granted. I usually don't ever see those granted. But that is one way that you could try to do it. But once again, it's not usually granted. So you want to talk to an attorney in your specific area and find out whether, the courts in that area, in that county, would do something like that.
If one spouse wants a divorce and moves out of the marital home, do they still have to pay some or all of the rent or mortgage and any other bills associated with the home?
The general rule is that if your name is on it, you should keep paying it. Your credit can be severely affected by divorce. If you move out of the residence and you just expect your spouse to keep paying all of those things and they don't, your credit is going to be affected. If you are the major breadwinner and you move out of the house and leave, the other person behind that doesn't have the ability to support themselves and then just refuse to pay all the bills, you will get in major trouble with the court. The court does not like to see that happen in Florida. That is a big no-no. So generally speaking, we always say to continue paying the same bills that you have traditionally throughout the marriage. You don't have to do anything new or anything crazy, but you want to keep paying what you were traditionally paying during the marriage. If you have an agreement with your spouse that you can move out and that they will pay the bills, make sure you get that agreement in writing and make sure they sign it. And of course, always talk to an attorney before you make any moves because they may have different advice based on your specific circumstances.
So if one spouse is going to keep the marital home and both spouses' names are on title, how can the other spouse be protected against mortgage debt post-divorce?
What we usually do is we put a provision in the settlement agreement or the judge will order that the property be refinanced out of the person's name who is not receiving the property. So in a settlement agreement, I will usually give something like 30 to 60 days for them to refinance the property out of the other party's name. So that will relieve the person of liability of that mortgage. But until that is done, you are on the hook. So I always try to also include a provision that says that if the party is going to be paying the mortgage late, or if they do pay it late, that they will let the other party know, so that they will have time and if they have the ability, they can make that payment so that their credit is not affected, and then the other party will pay them back for that payment.
If the divorce agreement states that one spouse is going to be responsible for certain debts, let's say the wife is going to take all the joint credit card debt, what happens if she defaults on the payments? Is the ex-husband protected by the divorce agreement?
Well, unfortunately not. When you sign an agreement with a credit card company saying that you are going to pay, even if your spouse also says that they are going to pay, That is your agreement with the credit card company. Your agreement in the divorce is going to be after that agreement. So it doesn't change what agreement you had with the credit card company. So you're always going to be liable for the debt as long as you are still on the debt. So you would still be liable. Now, there are things that you can do in the court if the person is not following what the divorce decree says. But this is why you always need to talk to an attorney and make sure that you hire an attorney to help you with your divorce, because as an attorney I craft agreements all the time that are very creative to make sure that we have an avenue for recourse if a person does not pay the joint debt. So it's going to be unique to your situation. So I can't tell you exactly what to do, but I can tell you that if you call a divorce attorney, they will have great advice for you.
If one spouse owned and ran a business during the marriage, is the other spouse entitled to a portion of it when they get divorced?
There are a few things that go into determining whether or not they will be entitled to a portion of that business. You look at both when the business was acquired and how the ownership documents were created. If the business was acquired during the term of the marriage and it's kind of a solo person company, generally speaking, it's going to be a marital asset, and it's going to be subject to equitable distribution. If it's a business that is created with a partnership, some other partner, and there's a specific partnership agreement that specifies how the ownership is held, then it's going to be treated a little bit differently. The other spouse may still be entitled to some kind of division, but it wouldn't necessarily be from the actual business. It may be that they get some other piece of property or some other asset in lieu of actually getting the business. So you really should talk to a divorce attorney about it. Your unique situation is going to be something that they will need to really look into, because businesses they're complicated, and it's something that they're very fact intensive. So you're going to have to provide all the documents from the corporation so that they can figure out exactly how that business is held to give you the right advice on that.
Does fault ever play a role in asset division? For instance, what if marital assets were used to fund an affair or a gambling addiction?
Those are two of the situations where fault would be used in an equitable division situation. If the wife has a paramour that she has put up in a penthouse and has been spending lots of marital assets on that, then the court will not consider those to be marital expenditures. They will put those in the wife's column when it comes to equitable division. Same thing with gambling debts. Gambling debts are a little bit different, but definitely for a paramour or a boyfriend or girlfriend, something like that, the court will not consider that to be a marital expenditure. When it comes to gambling, it really depends on the circumstances of the party. If the one party kind of knew the person was gambling and let them get away with it for a long amount of time, it's possible the court could just say, well, this is an issue that you kind of consented to. This person was doing this for a long amount of time, and you just consented to them spending their money this way. But if it's something where the spouse never had any idea and the money just kind of disappeared quickly and they filed for divorce, then yes, the court would consider that to be an outside expenditure and would put that in that person's column on the equitable division chart.
Let's talk about bankruptcy and divorce for a moment. If someone is thinking about filing for bankruptcy, should they file before or after the divorce is final?
It really depends on the types of debts and the amounts of debts. If the other spouse also has debts, and if there's a lot of joint debt, then it may be better for the person to file jointly with their spouse, and you can only file bankruptcy jointly with your spouse if you're still married. So I would say consult a bankruptcy attorney and see whether or not it's better for you to file as an individual or whether you to file, as a joint couple. And then if you're going to file as a joint couple, then of course you want to do it before the divorce. If you're getting rid of a lot of the debt, sometimes it will clean up some of the issues for the divorce. So if it's possible to do it that way, then I would say, it's sometimes better to do it before the divorce is actually done. If you're going to do it after, the court may still have you be depending on what the settlement agreement says. A lot of times we put in a provision that says that the assets or the liabilities will not be discharged by bankruptcy. So that may have an effect on your ability to file for bankruptcy. So definitely talk to a bankruptcy attorney and a divorce attorney and see what's best for your unique situation.
Does bankruptcy affect spousal or child support payments?
bankruptcy does not affect spousal support and child support in that if the bankruptcy is filed after you have already been ordered child support and spousal support, the bankruptcy will not change those amounts. Now, I will say that that in a divorce, if you are seeking spousal support from someone but that person is taking on a bunch of marital debt, sometimes the court will say, well, this person is taking on all this marital debt, so I'm not going to order spousal support because this person is really supporting the other person by paying all this joint marital debt. So in a way, it could affect the spousal support, but the actual bankruptcy itself will not take away your spousal support. It will not take away your child support. Those are two areas that are protected from bankruptcy. So if someone owes you $10,000 in spousal support or $10,000 in back child support, those debts are not going to ever go away in bankruptcy.
Does bankruptcy affect division of marital assets or debts?
It can, in that if there is no debt to be divided, then of course it makes your divorce a little bit easier. The actual process itself doesn't have anything to do with so the court won't say, well, because you filed for bankruptcy, I'm not going to make you take on any debt, or I'm not going to let you get any of the assets. It won't be used that way. But if you have gotten, if all of the debts have been discharged in a bankruptcy, then it may make your equitable division process a lot easier.
My guest today for this Divorce School podcast on division of property and debts and bankruptcy issues has been family lawyer Ginger L. Dugan from All Family Law Group in Tampa Bay, Florida. With 10 years' experience, Ginger has the skills and knowledge it takes to handle very complicated cases, and she's a dedicated advocate for her clients. For more information about Ginger and her firm, please visit her website, www.familymarital.law.com.